Am I free to go?
I want my lawyer now.
I want a lawyer right now.
Mr. Nolan, it's for you.
My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Today we're going to talk about the Oregon State Supreme Court. A recent ruling by the Oregon Supreme Court has banned a controversial policing practice. No longer can officers use a broken taillight or a failure to signal as an opportunity for scouting out a driver's car for illegal guns and drugs. Now, the ruling instructs officers to stick to questions reasonably related to the reason a driver was pulled over, effectively ending law enforcement's fishing expeditions during routine traffic stops. Now, this is an Oregon case, and it is decided based upon Oregon law by the Oregon Supreme Court. I am not licensed in the state of Oregon. This is not legal advice for Oregon, but rather a discussion about the broader implications of this case as it applies to other states and similar arguments in other states or under federal law. You have to remember, the logic used by the Oregon court is not controlling on any other state or the federal government. However, it is persuasive authority and can be used to make a similar argument. Now, here are the facts. Officer Faulkner, love the name by the way, Officer Faulkner of the Beaverton Police Department, you can't make this shit up, observed the defendant's vehicle changing lanes and turning without signaling. Now, Faulkner pulled the vehicle over, asked for driver's license, registration, proof of insurance, the typical rigmarole, and the defendant was able to immediately provide his driver's license, but he needed another 3 or 4 minutes to find his insurance and registration. Now, in Missouri, you don't really carry your registration. It's on the license plate, so they prove that. I mean, they've got registration when they run your plate. I don't know why you need a separate piece of paper for it, but that's the way they do it in Oregon. Crazy stuff. Anyway, while the defendant was searching for his paperwork, the police officer was asking questions. The passenger in the vehicle was interpreting because Faulkner speaks Spanish. He doesn't speak English. See where we're going here. So, at the beginning of the traffic stop, the passenger helped interpret. However, Faulkner told the passenger that she was free to leave. So she did. And she took off. After she left, the officer asked the defendant, and I can't pronounce his name, first part, Botello is the second part, but asked the defendant if he had any weapons, drugs, or other illegal items in the vehicle, and requested consent to search. The defendant's response to that was sure, okay, and consented to the search. During the search, Faulkner located a small package on the floor between the driver's seat and the door, and after examining the package, found it consistent to be drug packaging and found substance in it he believed to be methamphetamine. So, of course, the defendant was placed under arrest. A couple things on that before I go any farther on this. Okay, we've talked about some of this before, but first, the defendant didn't speak English. He didn't know if the officer was asking for consent to search or offering to buy him lunch. It's ridiculous. The second, never consent to a search. If the officer has probable cause, he's going to search. If he doesn't, don't consent. Consent cures almost all ills, as the court in this case rightly says. So don't consent. If you don't consent to a search and they search anyway, it's something we can argue. If you consent to the search, you're just, don't do it. Don't do it. Never. Don't. So the officer testified that his standard practice when contacting people was to ask if they have anything illegal in the car. Would they consent to a search for guns, drugs, knives, bombs, illegal documents, or anything else that you're not allowed to possess. If an officer says something like that to you, you think about what he said very carefully, okay? Just think about it. Let's phrase that another way. Hi, we just met, and this is crazy, but I'd like to handcuff you and drive you to my place for a strip search. Maybe some extreme power games, too. You know, it's bondage for the masses. No. If some guy came up to you and said that, your answer would be no. And if some guy comes up to you and says, hey, I want to search your car, your answer should be no. So, the trial court held that the officer's questions were during an unavoidable lull in the traffic stop. Now, unavoidable lull is, in Oregon, a term of art. The courts have held that unavoidable lulls happen. And the trial court held that the non-English speaking defendant consented to the search. The Court of Appeals agreed and affirmed the trial court in this case. However, the Oregon State Supreme Court said no. And the Oregon Supreme Court held that there are both statutory and constitutional limitations on an officer's authority to conduct investigations of unrelated crimes during a traffic stop. For example, ORS 810.410 governs the officer's ability to conduct an investigation during a traffic stop. And under that statute, officers are permitted to make additional unrelated inquiries only in special circumstances. And that's key. This case was decided under Oregon law, and it's Oregon's Article 1, Section 9 of its state constitution. And it sounds awfully familiar to another document. I'm going to read that for you real quick. Article 1, Section 9 establishes, quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search or seizure. God, that sounds familiar, doesn't it? Now, for the purpose of Article 1, Section 9, a seizure occurs when, first, the police officer intentionally and significantly interferes with the individual's liberty or freedom of movement. And two, a reasonable person under the totality of these circumstances would believe that his or her liberty or freedom of movement has been significantly restricted. There are essentially three types of encounter that a law enforcement officer can have that falls under this. You know, the first is mere conversation or a non-coercive encounter. You're walking down the street, police officer says, hey, how you doing? You talk about the Mets game. Don't know why you talked about the Mets game, his first name came to mind. The second, or we'll skip over to the final, the more serious one, the other end of that spectrum, is an arrest, which is a seizure under Article 1, Section 9 of the Oregon State Constitution. Now, a traffic stop falls somewhere in the middle of those two. It's not a perfect spot placement. There are gray areas that have to be accounted for, and that's why we have courts and lawyers. So, the court concluded that for the purposes of Article 1, Section 9, all investigative activities, including investigative inquiries conducted during a traffic stop, are part of an ongoing seizure and are subject to both subject matter and durational limitations. Now, when we say durational limitations, they're referring to cases decided under Oregon law. However, the Supreme Court in Rodriguez also says you can't illegally extend a traffic stop to wait for dogs or to conduct a search without having a particularized suspicion that gives rise to an independent constitutional investigatory hold. So, accordingly, the officer is limited to investigative inquiries that are reasonably related to the purpose of the traffic stop, or that have an independent constitutional justification, excuse me. Wow. Put simply, the unavoidable lull does not create an opportunity for an officer to ask unrelated questions unless the officer can justify that on other grounds. why this is important. We're going to be seeing cases filed in other states, and they're going to be referencing. We're going to be seeing defenses filed in other states, and they're going to be referencing the Oregon case. Okay, and the reason they're going to do that is because this happens in every state, in every police encounter. However, we don't have to rely upon Oregon law because we can constitutionalize this. The Oregon State Constitution, Article 1, Section 9, is from our Bill of Rights. So, we can constitutionalize that federally and make this argument in every state. The Oregon State Supreme Court decision is a powerful decision, and it's going to be great reference material for other states. The fact of the matter is a state Supreme Court has recognized that there are limits upon the subject matter questioning as well as the time that an officer has you on the side of the road. That is very important, it's very powerful, and by God, it is a good day for Oregon, and it's coming to be a good day for the rest of us. Please hit like, subscribe, smash the alert button, and I'll be talking to you later.